Welcome to another edition of Crime News with Mark Solomon. You've joined us on part 3 of a 3-part deep dive into the post-conviction motions filed on June 16 by the state in opposition to the defense's post-conviction motions for Derek Chauvin. So enjoy. If you haven't watched part 1 and 2, you should do that first. Until then, enjoy the show. So then he moves on to another huge topic, which is whether or not the prosecutor in this case committed prosecutorial misconduct, which is always going to be an allegation, especially in a high-profile case like this. And I've just gone and looked at a few. Like, for example, the court already rejected the the defendant's complaints about discovery. Again, discovery, always a heavily litigated issue in a trial. This is the one I wanted to focus a little bit on. There was some evidence that one of the jurors was wearing a BLM T-shirt at the trial, come to find out. And so the prosecutor is directly addressing this by saying that no slogan was visible under Mr. Williams' shirt in the courtroom, and if one was, the state was unaware. Let's stop there for a second. Remember when I was talking about whether or not perjured testimony, I'll try to put a link to the card in the video. I talked about witness perjury. And I was saying that in some jurisdictions, a prosecutor has to be aware of the perjured testimony for it to be a harm, to avoid the harmless error in trial. In other words, prosecutorial misconduct would have been committed if the prosecutor knew he was presenting perjured testimony. And here he's saying sort of the same thing. And he's saying even if the BLM logo was visible, he didn't see it. He was unaware. So that's important. Let's look at these points. The defendant presents no evidence that a slogan was clearly visible underneath Mr. Williams' shirt to the participants in the courtroom. The state's counsel questioned Mr. Williams at length and did not see a Black Lives Matter T-shirt. The record suggests the court, which faced Mr. Williams and sat feet away from him, also did not notice any kind of visible slogan. All throughout the trial, the court was acutely aware of the courtroom's participants' attire, and at one point the court observed a spectator wearing shoes wearing printed message and ordered the spectator be removed. So that's pretty powerful evidence on that. And he goes on to say that the defense now claims that he was wearing a clearly visible Black Lives Matter T-shirt under his white dress shirt and did not object or otherwise raise the issue to the court, which is really important. When a defense counsel sees something, the basic tenet of objecting is if you see something that's bad, you say something right away. If something happened that's bad, you ask for relief right then, right? And that's not what happened here. So, yeah, here it is. Either counsel did not see a slogan or the counsel intentionally remained silent to preserve the issue in the event the defendant lost in trial, in which case the court should not reward his strategic sandbagging. It's a very valid point. When you see something objectionable, you have to object. And when you have an objection which is granted or sustained, you have to ask for it to be fixed right then. Otherwise, you're basically saying it's not that bad of an issue. Okay, moving on to the next issue. Dr. Baker's brief comment about a federal grand jury doesn't constitute misconduct or warrants a new trial. And this is a concept where the witness testified to references to a federal grand jury, and whether or not, and since that was the state's witness, whether or not that would be considered prosecutorial misconduct. And in this case, his argument is basically that this was in response to defense questioning, which is essentially opening the door. It's an opening the door argument, which is where you can't talk about this because it would hurt the defendant, but if the defendant elicits comments or subjects or issues that brings it up, that's called opening the door to the subject, and that means that the other side can walk through. So you can't invite error and then claim it's not fair. That's the argument here. Moving on, and I'm almost done. The state acted completely properly during closing arguments, obviously. And let's see, I think there was one more, maybe not. I'm going to leave a link to the page in the below, but I think that pretty much covers what I wanted to cover. So when you're looking at this case, when you're looking at the issues that were raised and the responses now that we have from the state, it gives you an opportunity to weigh the arguments on both sides. Whether or not you have preconceived notions of your own, you can look at the arguments and decide if you were the judge, what would you do? I'd love to hear it. Put them in the comments below. we're going to be talking about this case for a while. But for now, today's episode was about the state's response to the post-conviction motion filed by the defense back on June 3rd. They've had 3 weeks to construct this memo. It's really long. It's really well written. I can't speak to whether or not it's well researched, but it's not a difficult read. You should read it. So that was the issue for today. If you would like your own issue in future episodes, please put them in the comments below. Email me or tag me on Twitter. I will bring it up. I've got a comment I just got while this video was going on I'm going to talk about. And remember, you always have a right to remain silent. If a police officer is asking you the who, what, where, when, anything, you have a right to say, I don't want to talk to you. And if they continue, I want a lawyer. Thanks for watching. I appreciate it. I'm going to keep you updated. And as long as I'm here, you will be getting good news and good reviews, and will incorporate your comments. Thank you so much.